warm welcome to the November event organized by the Committee of the Thames Valley branch of the Chartered Institute of Arbitrators. My name is Olena Chulinitska. I am here on behalf of the committee to represent our marvelous guest today, who is Mr. James Clancy. Mr. James was with the London Court of International Arbitration. He was a registrar, big thing, and he is presently with LexisNexis. James is also an associate member with the arbitration group at 6 Palm Court, an arbitrator, mediator, adjudicator, and a highly qualified English legal professional with a commercial acumen, which he would share with us today. I am not going to speak about the topic of his presentation because I am going, without further ado, to hand over to James. James, please, the audience is yours. We are eagerly waiting to hear you speak.
Thank you very much, Olena. And I'm flattered to have been invited by the Thames Valley branch to give a talk this evening. My talk is entitled The International Arbitrator and Identity Crisis. I'm pleased to be an ambassador for the London branch. It's a real pleasure to come to Thames Valley, even if only virtually. It's one of the compensations, isn't it, of the pandemic, that we are able in many ways to come together more easily than we would have had to if we had felt it necessary to travel. Here I am in Balham. Please excuse the sounds of any parakeets from Tooting Common, or indeed the fox families that turn up in our streets. But otherwise, I'm really delighted that I'm able to join you in Thames Valley, and the people from well outside of our areas are able to join us too. And indeed, that's really going to be the message of my talk, despite the somewhat forbidding title. It's great to welcome fellow members of the Chartered Institute, and indeed non-members. The Institute is a fellowship, and it welcomes outsiders too. And I think that it's so important, particularly at this time, that the international arbitration community should come together and recognize its own diversity, speak up for its diverse membership, and allow its members to learn from each other to the benefit of arbitration's users. And that's really the message that I have tonight. I should begin, first of all, obviously, with my thanks to Olena for inviting me, and indeed to Ben Beaumont, who very kindly endorsed the invitation and made sure that I came. I have, though, to begin my talk with a disclaimer of the kind that I normally make. Olena mentioned that I work part-time for LexisNexis, and I should make it absolutely clear that nothing that I say this evening necessarily represents the opinions of my employer, or indeed of any organization with which I am or have been associated. I should also preface this talk by saying I'm not intending to use slides. I've got so used to slides that I think we all have on Zoom presentations, and it can get somewhat wearing. But you will actually be able to find quite a bit of the material that I shall be talking about on my own personal website, including slides that I've used for previous presentations, which cover some of this ground, and there are some pretty pictures on those as well. For example, when I spoke about non-lawyer arbitrators and endangered species, I found a very nice photograph of a panda, which you will find on my homepage. So if you would like pictures, then do just check out my personal website. But I should also actually mention, I was very pleased to hear today that the next issue of the Chartered Institute's journal is coming out next week, all going well. And that will contain, I'm pleased to say, an edited version of a paper which I delivered at ICMA, the International Congress of Maritime Arbitrators, in Rio de Janeiro in March, just before the pandemic hit us all so badly and the lockdown started. I was very privileged to attend that last major conference in the international arbitration scene. And I gave a talk there on ad hoc arbitration and its enemies. And I will be touching in this talk on discrimination against those who practice in ad hoc arbitration and against arbitrators who mainly handle ad hoc arbitration. I think it's a problem that governments and indeed international arbitration associations and organizations tend to ignore or indeed act against the interests of a major constituent of the international arbitration community. So next week you'll be able to read my article. I also have another warning to make, which is that visitors from the London branch and other people may indeed have heard some of what I'm going to say before, but it will be quite considerably updated, have no fear. Things have changed in many ways with COVID-19, and the pandemic has got a lot of us obviously to think about things. And by that I mean matters relating to arbitration other than the organization of virtual hearings, which you can find extremely well covered, by the way, and Lexis PSL Arbitration's practice notes and guidance on how to conduct virtual hearings. But in my own arbitration practice, I didn't have any hearings lined up when the lockdown started. And my experience has been that the real concerns that I've come across are more to do with the cost and time of arbitration, as they always have been, and with different methods of conducting arbitration, ones that actually avoid hearings altogether. But anyway, I will be covering new ground then, but I need to move on to perhaps the most important disclaimer of all, which is that the title of my talk is International Arbitrator and Identity Crisis. And I need to be absolutely upfront now and acknowledge that there is no identity crisis as far as I'm concerned. There's not a crisis. There's no real crisis for international arbitrators. I put crisis in the title of my talk because I thought it would attract attention. And that's worked. I'm pleased to see the number of people that we've got this evening. It's very, very gratifying. I make no apology for this because this is completely normal practice in the international arbitration community. You take note of a phenomenon, you call it a crisis, you propose solutions, you secure speaking slots at conferences so that you can talk about it. And then if all goes well, you can put a task force together and then you can draft some guidelines. Now, anyone can draft guidelines, but if you are going to do that, and this is where, although I have no slides, I do have props. every now and again, I'm going to show you a copy of an article or a book. So the first one, which I urge everyone to have a look at because it's so important, is Michael Schneider's article, The Essential Guidelines for the Preparation of Guidelines, Directives, Notes, Protocols, and Other Methods intended to help international arbitration practitioners to avoid the need for independent thinking and to promote the transformation of errors into best practices. And Michael Schneider, in this extremely important article, which constitutes guidelines in itself, as he says, they're essential guidelines, very easy to access on his firm's website, LaLive. As he points out, one of his guidelines is one of the important things about guidelines is to make sure that they're easily accessible. And he has a section on who should prepare guidelines. I would just like to quote this because I do think it's so important. He says, guideline producers normally believe that they know better and that better knowledge and experience is a necessary qualification for guideline producers. There is no standard by which the asserted superior knowledge and experience can be measured. It is sufficient that the guideline producer makes an assertion to this effect and the inexperienced arbitrator and counsel believe it. Sometimes ordinary or average knowledge and experience is accepted as sufficient for the production of guidelines, provided the lack of asserted superior knowledge is compensated by a sufficiently large number of members in the group forming a guideline producer. In this context, total ignorance is no reason for being excluded from a group of guideline producers. In any event, limited familiarity with the subject matter should not discourage any guideline producer. However, in all cases, the guideline producers, or at least those who endorse the guidelines, must have some claim to authority. This claim may rely on the number of members of the group having drafted and endorsed the guidelines. Such a claim is strengthened if the group can point to a large number of different nationalities or other factors of diversity without there being a need to demonstrate that this diversity had any influence on the work product. The claim for authority also may rely on some official function, charter, or other form of recognition by a public authority. Once such a widely recognized position has been achieved, newly produced guidelines will receive much attention, irrespective of their subject matter and usefulness. Now, I've mentioned this because what Michael Schneider sets out there corresponds very much to the experience that I had when I was privileged to join the ICA Queen Mary Task Force on third-party funding in international arbitration. Queen Mary's Institute for Ethics and Regulation had explained third-party funding had been described as the climate change in international arbitration. It was said to give rise to a host of complex procedural, structural, and ethical issues. I was asked to the party quite late on, after I raised a query as to why the task force hadn't apparently yet addressed the types of funding which are current in maritime arbitration, which I've practiced, notably freight, demurrage, and defense cover. So the co-chairs very generously asked me to come and join the task force and tell them about this. The three co-chairs were all law professors. I was quite flattered. I was immediately labeled a leading expert because all the members of the task force were leading experts. The problem I found was that the other leading experts didn't want to hear what I had to say because I was suggesting that traditional forms of funding, of which they were apparently unaware, had been highly successful for decades, and maybe there was no crisis and no need to produce guidelines. No need to produce guidelines that was a crisis. So how to deal with me? Well, the solution that the task force found was actually in the end to say that maritime arbitration didn't fall within the scope of the task force's remit after all. So that's what happened. And the report came out in 2018, and here it is. And it explains precisely what I've just mentioned. There's a footnote, footnote 170, which is a footnote to a mention of the Whiting Case Queen Mary survey on international arbitration. Now, I would urge anyone who is listening, and all of my contacts indeed, to take part in the new Queen Mary survey, which has just been launched, because it's so important that the researchers should get as broad and various a picture of the international arbitration community as possible. In the past, this has not generally been the case. And that indeed is what this footnote acknowledges, because what it says is, notably, this survey and related discussions in international arbitration do not generally take account of practices in ad hoc and trade association arbitration, most notably in the maritime industry, which accounts for large numbers of arbitrations every year. These are among the reasons why this report does not seek to address funding in maritime arbitration. So there you have it. Because the Queen Mary International Arbitration Survey was not inclusive, the task force doesn't need to be inclusive either. That was apparently a good reason. Now, I would like to suggest that if an organization, or indeed a survey, is found not to have been inclusive, then it should make efforts to become inclusive. It should make efforts to learn about the members of the community whom it has ignored. You would have thought that that would be the proper way to proceed. It's rather depressing, therefore, I think. I was certainly rather taken aback in the summer when ICA produced a new report, which you can download online. So I don't have the full copy here, but you can print out the cover as I've done here in color. This is the ICA report of the Cross-Institutional Task Force on Gender Diversity in Arbitral Appointments and Proceedings. Now, the problem with this report is apparent from the very name, isn't it? It's been put together by institutions. Now, institutions administer a certain number of international commercial arbitrations. For those with a London seat, it may be bordering on 20% these days. The LCIA has seen a big increase in its caseload. But if you look at ad hoc arbitration, and if you look in particular at LMAA arbitration, those outnumber institutional arbitration in London, according to the Queen Mary report, the world's favourite seat, by an enormous margin. Indeed, last year, the number of new arbitrations commenced with LMAA arbitrators was higher than the total number of arbitrations filed with the ICC, the LCIA, and SIAC in Singapore added together. So ad hoc arbitration is really big. And then you've got the trade associations. You've got GAFTA, FOSFA, the LME, whose arbitrators are not lawyers, they're generally from the trade. They administer arbitrations, but they administer hundreds every year. So the international arbitration community, and indeed the community of international arbitrators in London and indeed in the wider UK, is quite diverse, and it's diverse by professions and backgrounds and businesses that people are involved in. Why would the institutions have authority to produce a report on gender diversity in arbitral appointments? It's not in institutional arbitral appointments. Indeed, when you read the text of the report, it's clear that the members of these institutions equated institutional arbitration with arbitration. The only mention of ad hoc, actually, is in relation to ad hoc committees in ICSID arbitration, not in the context of ad hoc arbitration itself. And as for non-lawyer arbitrators are non-personed in this report. That is to say, they don't exist as far as this report's concerned. They're just not there. Again, the report assumes that what it's actually looking at is career progression in the legal profession. It's heavily biased in that sense. Now, it seems to me, as I say, that this is a problem. I don't think it's a crisis. I think that it's really a question of making sure, where we can, that people's attention is drawn to members of our community who are being ignored. So, who are international arbitrators then? Who is it that I'm saying is being ignored, and who are the international arbitrators that are generally being talked about? Well, Ben Beaumont has a wonderful sign-off on his emails, which I like a lot, because in front of arbitrator, he has the qualifier when appointed, which may well be absolutely accurate. That is to say, before you're actually appointed in an arbitration, you are merely a candidate to be an arbitrator. But I'm not going to address that philosophical question this evening. Instead, I would like to look at, to start with, a sociological question, if you would allow me to do that. And the leading textbook on the sociology of arbitration is Dealing in Virtue, which is a fantastic book, actually. It is by Yves Désolé, a French sociologist, and Bryant G. Garth, an American law professor. It is interesting that there is a Franco-American strain in international arbitration, which I think it is worth recognizing. The surprising similarities between, for example, the way the American and French legal professions are run, the need to have postgraduate degrees, the acceptability in both those countries of unpaid internships, and the awe in which law professors are held. There are real similarities in French and American culture which don't really coincide with the way that international arbitration has been conducted in England. But those differences are all ones that we should be embracing. What shouldn't be happening, which is my strong view, is that any particular kinds of arbitrators should consider themselves superior or to have entitlements, and certainly not entitlement to the term international arbitrator. So anyway, Désolé and Garth conducted surveys of international arbitrators in many different seats. It really is fantastic work. It dates back now to 1996, but I do recommend it. Anyway, they say, when they're talking about the importance of arbitrators, they say the work of these arbitrators is rather glamorous. And at least for the large cases, it's a well-paid activity associated with nice places like Paris or Geneva and a first-class lifestyle. only a very select and elite group of individuals is able to serve as international arbitrators. Now, who are they talking about? Well, they certainly are talking about some of the people who we have seen on social media and on the many webinars that have been made available over the last several months, those who do indeed feel stranded and worried about the future because their identity is very much bound up with that first-class lifestyle. Not traveling to the hearings that they had in their diary has been a problem for them. But they have very often found new platforms with webinars and so on. And the great thing is that they are meeting new people who they might not have previously had the opportunity to meet. But we are talking there about a particular kind of arbitrator. When we're looking at who an international arbitrator is, what is the definition that would come up in academic circles? Well, I think the classic article is Catherine Rogers, The Vocation of the International Arbitrator. Let me just read you the beginning of Catherine's article. It's from 2005. She says, international arbitrators are exceptionally talented individuals. Now, none of us here this evening would have any quibble with that, and I certainly don't. That's absolutely fine. But it then moves on. Most speak multiple languages. They boast rich and multinational educations from the world's most prestigious universities and have vast experiences working in the highest echelons of diverse legal systems. Their multifaceted, multicultural legal training is often supplemented by technical or industry-specific expertise, and their cumulative credentials are frequently parlayed into professorships and enhanced by rich scholarly research. Really? When I joined the LCIA after almost 20 years in practice as a solicitor dealing with disputes in a well-known disputes law firm in the City of London, I hadn't come across professors as arbitrators. But that, I suppose, is partly because most of the arbitrations I was dealing with were disputes arising from international commerce. It may seem somewhat ironic, but in disputes arising from international trade and in shipping, the buying and selling of goods and the transporting of goods, then those arbitrations tend to be dealt with in ad hoc and trade association arbitration in London, where the arbitrators who are preferred tend to be close to the trade, close to the business. Law professors rarely feature. The lawyers who know the law in these particular areas best tended to be the partners in law firms, QCs, and of course the judges in the commercial court. The textbooks tended to be written by each of those people, not generally by law professors. That's not to say that there would be anything wrong in having a law professor as an arbitrator. And indeed, when I was at the LCIA, I came across law professors from many different jurisdictions. And so notably France and the US, and indeed, you know, Switzerland, many different jurisdictions, and some very fine arbitrators among them. But the idea that arbitrators are often law professors is a bizarre one. The problem is you can't just dismiss it, because the people who believe such things are also the people who are in charge of the task forces, as I've mentioned, the people who influence government and other organizations. The definitions of international arbitration, which assume a first-class lifestyle and professorships, don't help those ordinary businesses looking for quick resolution of their disputes in a commercial manner, whose voices aren't necessarily being heard. There are, real issues at play here. For an alternative view of who an international arbitrator is, you could always look at the English Commercial Court case of Aldcroft and the International Cotton Association, in which Mr. Arthur Aldcroft, a cotton arbitrator, sued the International Cotton Association because he felt that he had been deprived of part of his livelihood by a new rule that the Cotton Association had introduced, which was designed to limit conflicts and promote diversity by limiting the number of arbitrations that arbitrators could take each year in their arbitrations. What was interesting in that case from this sociological point of view is that the judge described Mr. Aldcroft's career in some detail, explaining how he had started out in the cotton business. He'd worked at combined English mills, and then he'd moved to Alexander Eccles and Stern, a Liverpool-based cotton merchant, where he worked until 2002. And it was then that he set up his own company, Aldcroft Cotton Limited, which was increasingly involved in international arbitrations for the International Cotton Association. And Mr. Aldcroft is based in Widnes, not in Paris or Geneva. He did not go, apparently, to university, let alone a prestigious university. His concern was that his livelihood was made up from his arbitrations. So many arbitrations was he doing that had basically become his way of life. He is an international arbitrator, clearly a popular arbitrator in the international cotton trade, clearly highly respected and trusted. That is why he received so many appointments, which was the issue which caused his dispute with the Cotton Association. Now, arbitrators of his kind are simply not recognized in so many international associations, in task forces, at conferences, but such people are the backbone of the international arbitration community. Indeed, Sundaresh Menon, Chief Justice of Singapore, in his keynote address for SIAC a couple of years ago, mentioned that the International Cotton Association was the forerunner of the modern arbitral institutions. The arbitration system that the Liverpool cotton brokers had put together back in the middle of the 19th century was the model for the modern institutions. Well, those were cotton brokers. They weren't lawyers. You didn't need lawyers to put this system together. Contributions from non-lawyers are extraordinarily important. They, in fact, are the foundation of international arbitration. And the way they get treated these days really needs questioning by those who study international arbitration. You probably don't need any reminder, but if you just pick up the UNCITRAL Model Law, Articles 1 and 2, and the footnotes thereto, you can see that international arbitration is very widely defined. It explicitly includes international trade, and it explicitly includes shipping as well. All of these businesses form part of the international arbitration community. And the people who are chosen as arbitrators in arbitrations arising in and between those communities, those people are all international arbitrators in their own right. I mentioned that there's discrimination against non-lawyers, and one of the problems is that with the proliferation of guidelines and rules, and with the endless need to create new ones, non-lawyers get marginalized by the lists of qualifications that get dreamt up for who arbitrators should be. And so there are, for example, in India, as you may know, they recently had some reforms to their statute there. There were some good reforms in India, and I've got nothing but admiration for the enormous energy and commitment of Indian arbitration practitioners who are looking to modernize their already extremely vibrant system. But one of the problems with the new act is that it's extremely restrictive about who can be an arbitrator. So there's a schedule to the act which sets out the qualifications and experience of an arbitrator. And you won't be surprised to know that number one is the arbitrator is an advocate having 10 years of practice. Now, there are other professions that do get an entry there. So there are accountants and engineers, but again, with years of practice and qualifications required. What we're looking at here then is a government which is seeking to regulate who can be an arbitrator. And what's being lost when governments do that, and indeed when institutions do that. So another example comes from Russia, which has been more and more prescriptive. So the arbitration center at the Russian Union of Industrialists and Entrepreneurs, it advertises what it calls its credible arbitrators. And it says that 16 of its arbitrators bear the title Honored Jurist of the Russian Federation. 50 of its arbitrators hold doctoral degrees in law. Well, how does that make them credible arbitrators? I'm sorry, I've got nothing against doctors in law. Of course, you know, they're clever people. And I know numbers of doctors of law who are fantastic arbitrators. But a doctorate in law doesn't make you a credible arbitrator. I think what we need is a bit of a reminder of the good sense from Cedric Barclay, a former president of the chair of the Chartered Institute of Arbitrators, who was the founder of ICMA, the International Congress of Maritime Arbitrators. He was a maritime and commercial arbitrator. He was a naval architect. He wasn't a lawyer. He used to say a lot of pithy things. And after he died, an article was put together which you can find in Arbitration International, 1989. It's called the Cedric Barclay Sampler, and it's got lots of his bon mots. But he said this, and I apologize for his use of male pronouns, but let's just imagine, as I'm sure he would in the modern world, be more aware. But he said, choose your arbitrator for his knowledge and experience, not because he has been recommended by a friend or is on a panel of an institute, or even because he has obtained degrees in philosophy and commercial studies from some backstate university. Sound practical knowledge should be accorded greater weight than theory. sustained reading of the more popular legal textbooks only leaves one with restricted side vision. I think he was right. He actually went on to say, there can be little hesitation in saying that in trade, engineering, or quality arbitrations, the interposition of a lawyer on the tribunal works as a brake on progress. Now, I think that's a little bit controversial. I am a firm believer that bringing different professions and people of different backgrounds together in a tribunal can produce some of the best results. But we are tending to forget the non-lawyers in our tribunals altogether. And I think that is a real problem. So as Cedric Barclay was indicating, what's important is to look for the right arbitrator for your case, someone who has the practical knowledge. What really matters is trust. You can trust someone who's got the right experience, but ideally someone who you know, or who has been recommended by someone you trust, or who has been appointed by an institution which you trust. The appointment, the selection of an arbitrator is really ultimately subjective. It can't be objective. That it seems to me is a myth. And this is where I have a concern about the current drive towards directories and data analytics, and in particular arbitrator intelligence, which was founded by Professor Catherine Rogers, who I mentioned earlier, who founded arbitrator intelligence as a database of arbitrators, which would include details about how they have decided particular interlocutory or procedural issues, so that you have an idea as to how they will conduct an arbitration. There are several difficulties with that, and one is the image of what an arbitration is. There's an assumption that an arbitration is something that is going to go to a hearing, that is going to involve all of these steps, that decisions are going to be needed on disclosure and so on. So there's a heavy bias, therefore, in favor of the arbitrators who have done those kind of arbitrations already. And indeed, there's the obvious bias in favor of the experienced arbitrator. Because a first-time arbitrator, there won't be data on them. Now, there are some explanations now being given by arbitrator intelligence that actually you can get some information from a single arbitration. But how much, really? If you have a look at the arbitrator intelligence website, it presents a preview of three of its reports on the diverse arbitrators on whom it now has reports after a few years of research. Now, the remarkable thing is that all three of those subjects, all three of the arbitrators in the previews, they're all law professors. All of them. All three of these diverse arbitrators are law professors. Now, it's maybe not surprising, because the networks which promoted arbitrator intelligence and the filling in of the questionnaire and so on were the ones around the universities, no doubt, and around Catherine Rogers herself. But this is not a diverse community that is being offered here. It's a real issue, it seems to me. And the problem there is who is an international arbitrator? Who's allowed to be an international arbitrator? Who's allowed to join this database in the first place? And as with, I'm afraid to say, as with the Queen Mary survey, which I do urge everyone to complete, the questionnaire, the AIQ for arbitrator intelligence, is rather off-putting for those whose arbitrations don't fit the mold that it's expecting, even from the beginning. You're asked about the filing of the request for arbitration. Well, that's something that only happens in an institution. Most arbitrations are commenced with the service of a notice on the other side. But that's not catered for. There's an assumption that an institution will make an appointment in default. There's no room for a trade association. Anyway, it's a little bit like that with the Queen Mary survey as well, where, for example, at the beginning where you identify yourself, you're allowed to say that you're an arbitrator and lawyer. You're not allowed to say that you're an arbitrator in any other profession, but you could put that in at other at the bottom. And I would urge non-lawyer arbitrators not to be put off and to complete other, and then in the comments explain why they are entitled to practice as arbitrators. But on this question of consulting directories, I'm very pleased to see that the Thames Valley branch has its own directory. It obviously needs a bit of expansion by the look of it, but it's called Find a Specialist. And that includes different professions, which is great. What's also really important, as I said at the outset, is networking. It's getting to know the members of the branch, getting to know the other professionals. And it seems to me it's through organizations like the Chartered Institute, particularly when we've got this possibility of communicating with each other in new ways, even if we rather do miss, as I do, the tea and drinks after a seminar with the London branch. But the membership of the Institute is hugely diverse in the UK and internationally. We welcome the law professors, but we also welcome the chartered surveyors, the shipbrokers, and all of those who make up the international arbitration community. And together we can challenge the elite. I wanted to end on a quiet note. I'm not in any way suggesting that people should be going to torch the BMWs in the Tilney Hall car park. But I think that we can quite seriously come together, and we can make sure that the fellowship of our institute counts for something. The fellowship means something, and that it can be a genuine fellowship of equals. Thank you very much. And I'd be very pleased to have questions and any comments as well. Thank you.
Dear James, thank you. We're very grateful for your wonderful speech. I thought that the interjection about the Courting Association was really delightful. That's not something which I came across, I'm afraid, myself, but I'm sure we have a diverse membership at Thames Valley, as you said, and I'm sure some people did. Now, there would be some questions, I understand. And first, very, very general question, which was put to us, is that would it be possible to make the materials which you referred to, or at least the titles of the relevant reports and the wonderful book by the French sociologist to be distributed to our attendees? That would be...
Yes, certainly. I'll put a list together, yes, of course.
Then, if I may just read out a question which was put to us. A friend who is highly experienced arbitrator was a technical expert in an LCA arbitration. The tribunal was 3 lawyers. When he asked why the LCA didn't appoint at least one industry expert, he was told that the LCA only appoint barristers. It makes no sense to me to have 3 lawyers on the tribunal. Thanks for the talk, James. So that's the reinforcement. But may I please ask you, ladies and gentlemen, should you wish to pose a very brief question to James, because we're now slightly constrained for time, perhaps maybe just post it in the questions comment, and I will read it out. Otherwise, please unmute yourself and speak in the orderly manner.
Hello,
well,
good evening.
Hello?
Hello.
Hi, I'm just really saying hello because there was a request for me to unmute. Just go on and I'll keep on listening.
We do have a couple of questions which I read out now. So that's from Fred Keys. Thank you for the great talk, James. I'm currently in the early stages of a career in quantity surveying. What advice would you give me to become an international arbitrator in the future? And I thank the gentleman for this question because Thames Valley is a very diverse branch, but we do have a lot of people with technical backgrounds. That would be pretty typical for our crowd. Over to you, James, please.
Well, it's obviously a good question. It certainly helps in international arbitration to have knowledge of the procedure and law relating to the conduct of an international arbitration. And if the arbitration is going to be at a seat other than London, with which people will more often be familiar, then it's essential to know what the law is going to be there. So I'm afraid that even for the non-lawyers, my advice is to familiarize yourselves with the procedural law at least. And of course, the Chartered Institute has its international arbitration diploma, and it has other courses which are extremely valuable. As to obtaining appointments, as for example, a quantity surveyor in international arbitrations, it's my view that what really matters is to get to know the people who are more likely to be involved in international disputes, which might benefit from your knowledge and experience. Having seen, I think it was Steve Devereux's comment earlier on LCIA tribunals, it was not my experience when I was at the LCIA that there was any bias against non-lawyer arbitrators. I certainly didn't hold that as registrar. But what we did see was that parties, or rather their lawyers, tended to appoint lawyers instead. And there's quite often the tendency that when the claimant has appointed a lawyer, the respondent thinks it had better appoint a lawyer as well. And then two lawyers tend to appoint a third as the chair. It tends to work out that way. The institution will make appointments where the parties haven't agreed, and under the LCA rules, that's the primary system that the institution makes the appointments. But I have to say that it's comparatively rare for cases to come up where non-lawyers would be, shall we say, the obvious choice. So my advice tends to be these days that it's hard work persuading institutions to appoint you. It seems to me to be better to do as much networking as you can amongst the advisors and the commercial parties, and any cases that have an international element, latch onto them.
Thank you, James. We have two questions. One from Miss Karina Albers, who raised her hand, so I presume she would like to ask it in person. And then the very quick question from a gentleman with an engineering background, asking if he has a better chance of being appointed if he is an engineer and a lawyer.
Mm-hmm. That's a good question.
So how it's up to you, James, how you would like to take it.
Well, I could answer that second question first, and then turn to Karina, if that's all right. It's been my experience that engineer-lawyer arbitrators are amongst the very best. And I was always keen to see engineer-lawyer arbitrators appointed in LCA arbitrations. But it's not necessary, as I've been saying, it's not necessary to have a law degree, particularly not if it's a 3-member tribunal and the technical knowledge is needed. So I think it's definitely worth considering doing a law degree if you're already an engineer and if you've got the appetite for it. It could definitely help, but it's not essential. So, Karina, what was your question?
Well, I don't actually have a question. I just thought I might sort of support your argument that, first of all, I think, yes, it's certainly the Chartered Institute qualifications to reach the fellowship is really fantastic for anybody that does not have a legal background. I myself are a non-lawyer arbitrator, and that certainly for me was essential before I really understood also how the parties would argue their issues. But in addition to become an arbitrator, yeah, first of all, so the Chartered Institute Fellowship is definitely a great qualification for it and gives you a fantastic background. Then I would agree network is very important, but the most important thing is that people know your unique skills and expertise they have, and that you highlight those to the people that actually hand out appointments. So you need to identify in your field who would actually hand out the appointments. And the other thing I found was very helpful as well, if you publish papers within the legal community that address legal points, but highlighting your expertise. So I hope that helps, because it definitely has helped me, I think. Yes, it is a lot harder to get appointments as a non-lawyer arbitrator, but nevertheless, once you actually have got a couple of appointments under your belt, they actually keep coming, because people appreciate your skills that you bring to the table. And that, as James has said, engineering degrees with legal degrees combined is the best of the best. So yes.
Thank you.
Thank you very much. Thank you very much, Karina. James, I think we have just enough time for the final question, which is also a permutation of a previous question. It's from Akua Alda. Apologies if I mispronounce the name. As a practicing civil engineer in Guyana, South America, how do I stand with regards to entering the industry?
Well, it's another good question. Well, certainly, civil engineering can be an important background for an arbitrator in international disputes. Now, if you're in South America, that's a hugely developing area as far as international arbitration is concerned. The ICC and other institutions have seen enormous growth there. And indeed, South American arbitrators, I'm thinking in particular of Brazilian arbitrators I know, are building up practices in Europe and elsewhere too. The world, as we can see tonight, I mean, I'm in Balam and hear all these people in Thames Valley and even in Guyana. the world is growing smaller in so many ways. And the fact that you might be in Guyana should not be an impediment in the way that it might have been even just a few months ago. I think we are moving to a world where a lot of arbitrations will actually be conducted completely online. It won't be necessary to cross the Atlantic or whatever. So there could be huge possibilities opening up for people around the world. As to how civil engineer arbitrators might be perceived in your own jurisdiction, I couldn't really comment. I do have a concern that in some jurisdictions, there is, partly because of the civil law background, there is a tendency to hold in perhaps too high regard the law professors and the lawyers who generally make up the international arbitration communities there. And I think the Chartered Institute has a real role to play. It's always seemed to me, it's got a real role to play in taking, if you like, the message from 12 Bloomsbury Square, that this is a fellowship of many different professions. At the moment, I've got a slight concern that when the Institute is opening up to younger people, and it's talking about arbitration practitioners, it seems to be talking about young lawyers and law students. Where are the civil engineers? You know, where are indeed the shipbrokers and others who will become arbitrators later in life? Why isn't the Institute really promoting them? And that would help with people in your sort of situation in Guyana. If the message could come across that this international body promotes non-lawyer arbitrators like yourself, that would really help. That's definitely a message to convey locally.
Thank you, James. Being somewhat conscious of time, I will ask you a last question, which in fact is very interesting and stimulating question about bias and technical backgrounds and what it goes about. It talks about being an engineer. Chris Cabral is asking, engineers will almost have their own opinions and may prefer one design over the other. Thus, in the construction industry dispute, will the element of bias be raised due to possible preference of design? So if you see, it's a clever way of putting it. Would my excess of knowledge be a disadvantage in being an arbitrator, really?
Not necessarily. That's an interesting question, because of course similar questions arise in relation to lawyers, and particularly in relation to lawyers who publish articles. So in particular, to lawyers who might be part-time law professors or whatever. So if they've expressed an opinion as to how a particular contractual term should be interpreted, or classically in investment arbitration, if they've expressed opinions on the interpretation of traditional wording in bilateral investment treaties, then they can face challenges on the basis of bias that is visible through their published work. Those challenges don't tend to succeed. And of course, one reason for that is that if you do have a tribunal of three, then the idea is that bias or a particular adherence to a particular way of approaching an issue will be balanced on the tribunal. But of course, the other point is that holding opinions about the law doesn't necessarily translate into bias. Opinions can be changed, but holding an opinion can also indicate that you have knowledge of the subject matter, that you have actually invested time and energy in investigating it yourself. And in shipping arbitration, for example, in which I've practiced for a long time, there are arbitrators who are known to hold particular views, who are frequently appointed because they're members of the community with profound knowledge. But it's a really interesting question about designs, and I couldn't pretend to know quite how a bias challenge might work in that context. Thank you.
Thank you very much, James. I think, ladies and gentlemen, we are somewhat overrunning. So unless there is a desire on part of anyone here present to ask a last question, I will draw our session to the close and will thank our wonderful speaker, Mr. James Clanchy, for the most informative, intelligent, and very intellectually stimulating lecture. And I would also like, on behalf of the Committee for Thames Valley Branch, to thank you, our audience, which made this session so pleasant, and for all your comments and your active participation. I attended a lot of webinars, and I think this present one is a good example of how things could go. And I hope you would agree. So thank you and good evening.
Thank you, and thank you for the excellent hosting. Thank you.
Thanks, James.
Thank you.
I'm going to have a well-deserved glass of wine now, James.
Thank you.
Thank you.
I'm going to have one.
It's a good idea.
Well, maybe when the lockdown is over, and at some point we are back to the situation where we can lay out the refreshments and a cup of tea as well. I think